The Supreme Court heard arguments today in cases seeking to end the practice of considering race in college admissions. Cases center on the country's oldest public and private universities, the University of North Carolina and Harvard, and they claim that the schools violate equal protection principles and discriminate against Asian American applicants by considering race as a factor, or a so-called plus factor in the case of UNC. The group Students for Fair Admissions, led by conservative activist Edward Blum, is behind both challenges. And while lower courts have ruled in both universities' favor in the past, the conservative majority in the Supreme Court today appeared very interested in Blum's arguments.
I don't see how you can say that the program will ever end. Your position is that race matters because it's necessary for diversity, which is necessary for the sort of education you want. It's not going to stop mattering at some particular point. You're always going to have to look at race because you say race matters to give us the necessary diversity.
Chief Justice Roberts. I'm joined now by Natasha Warikoo, professor of sociology at Tufts, whose book Race at the Top, Asian Americans and Whites in Pursuit of the American Dream in Suburban Schools came out earlier this year. Richard Kahlenberg is the author of The Remedy, Class, Race, and Affirmative Action. Also recently wrote a piece on the topic for The Globe, testified as an expert witness for the plaintiffs when their case was heard in the Fourth Circuit, and just stepped out of the Supreme Court where he listened to all 5 hours of arguments. Richard, Natasha, thank you both for your time. I appreciate it.
Great to be here.
Good to be here.
Natasha, why should the Supreme Court allow race to be a factor in admissions?
Well, it seems pretty clear that, in the previous cases that came to the Supreme Court, the court has affirmed that diversity is a compelling state interest. In order to create diversity, we need to have attention to race. I didn't hear anything today that negates that consideration, that suggests that race no longer plays a role in American society. So, I think that it's pretty clear, and we have a lot of evidence that there are all of these benefits in terms of educational benefits to a diverse learning environment.
So, Richard, again, I mentioned you're an expert witness for the plaintiffs. What do you think this court should be doing?
Well, first of all, I agree with Natasha that there are tremendous benefits to racial diversity on campus, and I want to make sure that we have paths to get there. But the research that I did for the case suggests that there are so-called race-neutral alternatives, that is, other means to getting racial diversity and the benefits that come from that. Harvard right now, for example, is majority minority, which is a beautiful thing, but it has 15 times as many rich kids as poor kids there. And if they were to give a break to economically disadvantaged students of all races, and to get rid of the terrible, preferences they give to rich kids through the legacy alumni preference, then you could get racial diversity without all the division that is associated with using race.
Before we hear what Natasha thinks about your proposal, you say in your piece in The Globe, again, you assert, as you do a second ago, that diversity is essential. The two of you agree on that. You say it's appropriate to use race as a last resort if other means could not achieve sufficient diversity, but the plaintiffs on behalf of whom you are testifying don't agree with that at all, correct?
That's right. I have a different position from Students for Fair Admissions. I think that race-neutral alternatives in the vast majority of cases will work, and so you don't have to use race. But if there were an unusual circumstance where, let's say, an institution was located in an all-white state where it was hard to get Black applicants to apply, and they did everything they could through race-neutral alternatives, then I'd leave the door open a crack for race in those circumstances.
Natasha, what do you think about Richard's alternative to, according to him, achieve the same end?
Yeah, well, let me first say that I agree with Richard that absolutely these colleges need to be paying a lot more attention to class and that they need a lot more class diversity. There's a dearth of students who are working class, poor, and even middle class and lower middle class. And so absolutely there should be a lot more attention to social class. But the evidence suggests that, even if we look at class, there are more young people who are poor, more of our poor are white than are Black or Latinx, because that's the population of the United States, that attention to class is not enough to achieve racial diversity. ending legacy admissions, reducing or ending athletic recruiting, all of these other kind of factors that were mentioned in court today. The data suggests, that came from the case that these are, that these will not be sufficient to achieve the racial diversity that affirmative action does. And that's pretty clear. So absolutely, I think we should be paying a lot more attention to class, but that's not a stand-in for race. And I think we need to look at both of these things. It's not either or, to me, it's both and.
How about it, Richard?
So in theory, I agree that I could see a world in which universities considered socioeconomic status alongside of race. I've been at this 30 years though, and the one time that universities start paying attention to class diversity is when they tool to use race to recruit upper middle class students of color is taken away. So in California, in Michigan, in Washington State, in Texas, Florida, that's when they really started paying attention to class, when they could no longer use race. And it was only then. So in theory, universities could do race alongside class. They never do though, in fact, because it's much cheaper for a university to give preferences to upper middle class students of color. That's what Harvard does. 71% of the underrepresented students are advantaged, socioeconomically advantaged. And so the way to get to the path of class and racial diversity is to use socioeconomic status as a way of moving forward.
The one thing you both don't seem to agree on, do agree upon, that racial diversity matters. When I hear comments like at today's hearing from Clarence Justice Thomas, one of my least favorite things is when smart people play clueless, and he did that today. I've heard the word diversity quite a few times. I don't have a clue what it means, he said. Starting with you, Natasha, maybe it's necessary to do this. You touched on it at the top. Why does diversity matter other than to the individual involved? Why in the big picture does it matter?
Well, after the Bakke decision in the late 1970s, a lot of social scientists went to task and said, well, what are the benefits of a diverse learning environment? And we see that there are, students who are on more racially diverse campuses feel a greater sense of self-efficacy. We know that diverse groups make better decisions, are better at solving problems. They find down the line that there is greater civic participation, greater sense of efficacy in terms of leadership. So there strong, better racial attitudes. So we know that there are all of these benefits. And I'll just point out also that we can look at what happens when we end affirmative action by looking at states, as you mentioned, Richard, like California, Michigan, Texas, and it's not good. We see year-on-year declines in the percentage of underrepresented minorities on these campuses. There are knock-on effects on graduate schools. Those students are then less likely to graduate college and go on to graduate school. There are fewer doctors of color who are Black, Hispanic, or Native American because of this. And we know that having a same-race doctor has an impact on Black patients' care. So there are all of these reasons why, we already know what will happen, and it doesn't look good. So I think, suggesting that they'll find class-based alternatives hasn't been the case so far.
Richard, you have the benefit that neither of us do. We both read about it. Neither of us were in the courtroom. You were. The media is suggesting, court observers suggest that affirmative action is gone as soon as the decision is written. Do you share that perspective based on the oral argument?
Well, going in, we knew that it was 6-3, a conservative liberal divide. And there wasn't anything that I heard from any of the conservative justices that suggested that they really like the status quo and were ready to support Harvard and UNC. I think I see a much brighter future than Natasha does, though, on this. I mean, my reading of the evidence is in places like California. So that UCLA, to take one example, UCLA is 6% African American in a state that's 7% African American. UNC, which uses race, has an 8% Black population in a state that's 22% Black. So UCLA is doing pretty well in terms of finding race-neutral ways to get racial diversity. And on top of that, UCLA, UC Berkeley, these institutions are among the top two for socioeconomic diversity. So they are able to accomplish both goals. I mean, to their credit, higher education is dedicated to racial diversity. And when the tools are taken away, the kind of the bluntest tools, just preferring wealthy students of color, they find new ways to get racial diversity. And so I read those stories as much more successful than some have suggested.
If the Natasha, if the result is a 6-3 or 5-4 decision, dumping affirmative action as a consideration or saying that it can't constitutionally be considered as a factor, what do you see in the future?
So, well, let me just say that, I think it's not a done deal. I think there were a lot of questions about this, like, when does it end? And, I think Amy Coney Barrett in particular was, kept pressing this question. Okay, what about that 25 years that Justice O'Connor mentioned in 2003? Or if it's not 25, when is it? And so, I think that, I think there is an opening there. So I don't know that it's, I don't know that it's a done deal.
Well, let's assume it is, just for argument's sake.
So, if it is, I think it's not good. And again, I think we can look at states that have banned affirmative action to see what will happen. I think we will see a decline. We will definitely see a decline in Black, Latino, and Native American students on these campuses. I think the colleges will work hard, as Richard said, to try to increase the number of underrepresented minority students. I think it will be hard. Perhaps they will pivot to asking people to talk more about their biography, because, it was interesting that the plaintiffs said that, you could consider race if a person talks about race-based discrimination or adversity or even just cultural identity.
And how it affected their lives.
Okay. So,
that was Chief Justice Roberts, right, today, I believe?
Chief Justice Roberts and the SFFA lawyer as well.
One last thing, if I may, maybe this is more appropriate for you, Richard, but if not, one of the things that I've never been able to quite figure out is how a man who admits that he benefited from affirmative action at Holy Cross and benefited from affirmative action at Yale Law School is probably the most powerful opponent of affirmative action as an older man. That, of course, would be Associate Justice Thomas. Do you have any insight into why it was good for him but not good for those after him?
Well, I think it's dangerous to speculate, but I would say that there are beneficiaries of race-based affirmative action who are resentful that their meaningful accomplishments are under a cloud. And so to the extent that this plays into Justice Thomas's views on affirmative action, I think it's perfectly logical and reasonable for someone whose accomplishments are doubted because of race-based preferences would say maybe there's a better way. And he is a very strong champion, by the way, of socioeconomic preferences. He says, the young Clarence Thomas did deserve a socioeconomic preference in admission. But
he got a racial preference.
Right, but I'm saying that the next generation wouldn't necessarily. Obama has said that his kids don't deserve a leg up in admissions, but lots of the beneficiaries of socioeconomic preferences will be people like the young Clarence Thomas.
Natasha, you have any quick insight on that?
I can only speculate at what goes through Justice Thomas's mind. I think that he, I don't know what he would say. I think he's, pretty opposed to any kind of consideration of race. And, I think the question he kept asking, what is diversity? What is the benefits? Felt a bit disingenuous, because there is all of this research on the benefits of a diverse learning environment for students. So,
Natasha, I appreciate your time. Richard, thanks for coming in sort of from out of the rain. I appreciate you both. Thanks so much for your time. Really appreciate it.
Thanks for having me.
Thank you.
Thank you. Bye-bye.